The language of the agreement is not confusing. The intent of the language is crystal clear. The violation is egregious. There is a statute that says this agreement is enforceable. There's a case that's just about dead on point. None of which, in their brief, Ms. Fisk attempts to challenge. Instead, she tries to split hairs over the language. Oh, well, he's not entering into a business relationship with the doctor. He's going out on his own. Well, you can enter into a business relationship with yourself. You can have a single member LLC, which he does. You can have a sole proprietorship. You can be a proprietor of a business. And he is a licensed doctor in the state of Michigan. He has violated the agreement and he knows it. And what this court has to decide is, you know, sometimes you come into court on these things and you have arguments about whether the agreement is reasonable, whether there's really a protectable business interest there to be protected. You know, I mean, I've represented a lot of employees on these types of cases too, and there are times when these agreements are not enforced. But frankly, this one's just not even close. I mean, this court has to decide, are we going to enforce Michigan law on restrictive covenants in this court, or are we not? Because it doesn't get any clearer than this. A doctor left, opened a practice less than a mile away, directly solicited the patients, hired former employees, did it in total violation of the agreement. Statute says we can have this agreement. The case law supports the fact that patient relationships procured while he was employed there are a protectable business interest of Double Chiropractic. 7 miles has been determined to be a reasonable geographic restriction by the Court of Appeals. This case that I've cited has been recited and followed about 50 times. It's dead on law. And while it's unfortunate, as it often is, when these things, have to be enforced, because I understand the negative impact it's going to have on Dr. Ferry, this court has to concern itself with the negative impact of his choice to go out and completely ignore the agreement that he signed, to completely ignore the 10 years that Dr. Double put into helping him develop these contacts, paying for him to develop these contacts, go out and violate this agreement. The court needs to consider Double Chiropractic's rights and its own interests here and Michigan law here. And while it's a tough decision, it's a situation that, frankly, Dr. Ferry brought upon himself. If he'd have gone out and opened a practice 13 miles away and not solicited our patients, we wouldn't. Frankly, if he had just gone 6 miles and not solicited our patients.
Mr. Beer, I'm sorry, but I'm going to limit your argument. Can I get a response?
I feel like you understand.
Thank you, Your Honor. Your Honor, I understand that Mr. Beer thinks that we're splitting hairs over this contract language, but Michigan law is clear, and I'm asking the court to also enforce Michigan law as it's written, which says that contracts have to be enforced by their clear language. If Dr. Double is dissatisfied with how he drafted this and the language isn't specific enough to what he was trying to prohibit from Dr. Ferry, that's his problem, not mine. The language of the document speaks for itself. Mr. Beer would ask this court to impose additional language here that just isn't there. He plays on the word proprietor and somehow indicates that makes or breaks my situation. It doesn't, Your Honor. Proprietor in and of itself just means he may have an ownership interest. That's it. It doesn't mean you're a sole proprietor. It means proprietor. The language of this document does not say sole proprietor. It specifically prohibits, the clear language prohibits Dr. Ferry from entering into a business relationship with any doctor licensed in Michigan within 12 miles. That's not what he did. He went and opened his own practice, period. Mr. Beer would submit to the court that somehow my client did this in a backdoor fashion, in a backroom fashion. Point number one, he was an at-will employee. At the end of the day, he was under absolutely no obligation to give Dr. Double notice of the fact that he wanted to leave, plain and simple. And if he did, he probably would have been terminated early. The second point is, Your Honor, the defendant, Dr. Ferry, specifically sought out counsel to interpret the contract before he ever left to make sure that the steps he was taking in opening his own practice were not violative of that covenant. He took steps. This wasn't something that he took lightly. He wanted to make sure that what he was doing was appropriate under the terms of that agreement. He recognized the agreement, and a letter was sent to Dr. Double setting forth the interpretation of that way back in March when Dr. Ferry originally left. It took Dr. Double months to decide that this was of such an imperative situation that he needed to file a lawsuit and ask court for a preliminary injunction. If it was so serious, why didn't he file it right off the bat? Why didn't he file it almost immediately after receiving notification from counsel for Dr. Ferry indicating his intentions? In the meantime, Dr. Ferry has opened a practice, signed a lease, spent money in opening this practice. He has employees that depend on him for wages. He himself depends on this business for his wages. And we wait several months before filing a lawsuit. It doesn't make sense, Your Honor. The fact of the matter is, we have a motion for summary disposition pending on this particular issue, the interpretation of the covenant not to compete itself. I think it's a dispositive issue. I think the court will, when it gets into the beat of it, will understand where we're coming from. And the case law can't be ignored. Case law indicates that contract interpretation begins and ends with the written words themselves. Dr. Double, like it or not, is stuck with what his language indicates. And with all due respect to Mr. Beer, as far as the background as to why Dr. Double created this covenant not to compete and asked Dr. Ferry to sign it, it doesn't matter. That's parole evidence. It doesn't matter. The contract speaks for itself, and Dr. Double is stuck with what it says. With respect to the confidentiality provision, Your Honor, I think that we have a situation here where Mr. Beer is setting forth an issue that we don't even know exists yet. They're arguing that Dr. Ferry must have taken a patient list, that he must have stolen files from Dr. Double's office. There's no evidence of that. They've presented nothing in their motion to that effect. The only thing that they are relying upon for that purpose is a postcard mailer that doesn't specifically target Dr. Double's patients, as Mr. Beer would lead you to believe. It's a very generic postcard. It's a marketing tool, and it was mailed out, generally speaking. And yes, we admit that some of Dr. Ferry's patients that he treated while he was employed at Dr. Double's office received that postcard. It didn't happen a second time. It hasn't happened a third time. It went out one time shortly after Dr. Ferry opened his practice. That does not in and of itself prove to the court, however, that Dr. Ferry somehow pilfered confidential information. I'll remind the court, Dr. Ferry was employed with Dr. Double for 12 years. In 12 years, he treated a lot of people. He treated a lot of patients for which he learned who they were, he learned what their ailments were, and he learned how to treat them. That is not necessarily an indication that he stole that information. It's knowledge he can't unlearn, it's knowledge he has, and if the court takes a look at the Hayes Albion case, which is, again, like Mr. Beer indicates, a seminal case relative to confidential information, it clearly indicates that identity of clients or patients is not protected information. Client lists might be,
So
patient information might be.
Ms. Fisk, regardless of whether he used protected information or not, if he sent postcards to patients he treated when he was employed by the plaintiff, how is that not a solicitation, and how is that not a violation of the non-solicitation provision of the agreement?
Your Honor, in the event that the plaintiff proves that there was a loss of some kind related to that postcard, I do not dispute that there certainly could be an interpretation of a violation of the non-solicitation paragraph. Mr. Beer, however, hasn't shown this court that Dr. Double has lost any patients as a result. He's attached nothing to his brief to show that. And furthermore, Your Honor, a preliminary injunction requires irreparable harm. Irreparable harm is non-compensable. If Dr. Double has an argument that he has lost patients, that's compensable and that's money damages. That does not meet the terms for a preliminary injunction. That's clear law, Your Honor, and that's cited in Mr. Beer's own brief. You have to have irreparable harm first and foremost before you can ever get injunctive relief in this court. So I'm not here to argue that necessarily a violation of the solicitation paragraph hasn't occurred by a single postcard, But I am going to argue ardently, Your Honor, that he has not met his burden of showing that this is not an otherwise compensable damage that could be dealt with by money damages. So to the extent that they're asking for this court to shut Dr. Ferry down on that principle alone, they haven't met their burden. And it's a high burden to meet. So hopefully that answers your question, Your Honor. But I think plain and simple, irreparable harm hasn't been shown. And Thermatool makes that clear. That case is absolutely on point, Your Honor. And a non-compensable injury is required for irreparable harm. Your Honor, just a couple more points I'll make. The plaintiff has to show balance of harms and has to show that somehow the plaintiff is going to be harmed more so than the defendant in this case in order to obtain a preliminary injunction. I think it's clear, Your Honor, that without question, Dr. Ferry has more to lose here than Dr. Double. Dr. Double's been around since 1991. He has an established book of business in Jackson. Dr. Ferry's new. He just went on his own and invested all kinds of money and time and energy into opening his own practice. Dr. Double had notice of that in March and waited until several months after Dr. Ferry had taken all of these steps to move forward. The balance of harm absolutely weighs in Dr. Ferry's favor in this case. And as far as public interest goes, Your Honor, I don't disagree with Mr. Beer. The public has an interest in the court's enforcement of contracts, but to go a step further, the public has an interest in the court enforcing documents as they're written. We have a doctor who was given a non-competition and non-solicitation agreement to sign, and it was prepared by the person asking him to sign it. He reads it, it reads how it reads. He seeks counsel to find out whether or not the steps he wants to take in opening his own practice are appropriate, gets the go-ahead that, yep, by the clear terms of this contract, what he's doing is perfectly acceptable, goes ahead and does so, and Dr. Double waits months before he chooses to file for a preliminary injunction and file a complaint in this case. Something's not right. I submit, Your Honor, that Dr. Double and his counsel probably recognize the fact that there are some deficiencies with this language and how they want to enforce it, and maybe they missed something. But the background, as far as that goes, makes absolutely no difference, Your Honor. I don't think that the plaintiff has met its burden, Your Honor. I don't think a preliminary injunction is appropriate, and I would ask that the court deny that motion.
All right. So the focus of the court's attention this morning is exactly on this language. The defendant would have the court essentially interpret the language, any business relationship with any doctor licensed in the state of Michigan, to read that as any business relationship with any other doctor licensed in the state of Michigan. Granted, the drafting could have been clearer, but based upon the circumstances, I think this language does encompass exactly what Dr. Ferry has done. I'm going to issue a preliminary injunction prohibiting him from conducting a chiropractic business within 12 miles of the defendant. Mr. Beer, you'll prepare that order?
I will, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Bank of America versus Raymond. Is anyone here on that matter?
Yeah, good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
I didn't get that.
Spell your last name, please.
W-E-R, B as in boy, E-R.
Is anyone else appearing on this matter?
Your Honor, we have not served the defendant yet. I know that she reached out to your clerk. She has sent in some payments. We haven't had a formal resolution yet. This was filed right before the stay-at-home order. Our client did not want to serve anyone during that order, so it's now back out for service.
Okay, fair enough. We'll get you a new date.
All right, sounds good. Thanks, Your Honor.
Thank you. Sorry to keep you waiting.
No problem.
Federal National Mortgage versus Green Tree. Is anyone here on that matter? Hold on a minute, I see somebody in the waiting room.
Okay, sure enough. Okay, okay.
Federal National Mortgage versus Green Tree. Is anyone present on that matter? All right, doesn't sound like it. Ostrander versus Ostrander.
Good morning, Your Honor.
Good morning. Mr. Phillips, I assume?
Yes.
Okay. Ryan Phillips for the plaintiff. Anyone from Mr. Schroeder's office?
Judge, if I may be heard,
Go ahead.
I sent you by email a signed stipulation to dismiss. If you'd be so kind as to enter it, you
I
can
will
conclude this
be
matter.
happy to do that. Let me
Thank you,
make sure
Judge.
that I got it. Hold on a second. When did you send it? Oh, I see
Perhaps-
it. I see it. I will sign and get that out. Thank you.
Excellent. Thank you, Judge.
Okay, next up. Bank of America versus Burkholder.
Good morning, Your Honor. Andrew Kirkpatrick on behalf of the defendant Maxine Burkholder.
Cullen Geis on behalf of the plaintiff, Bank of America.
Okay, we're set for a pretrial here. I'm guessing, Mr. Kirkpatrick, since you just got involved in this matter, well, actually, I don't know. Maybe that's a wrong assumption.
It's Mr. Ellis, and I believe that's him, but he might be on mute.
Yeah, he's muted.
I've been in this since the beginning, Your Honor.
Yeah, and
Okay,
as
Oh.
Mr. Weber, it's the other Bank of America case. My client still is under the resolution that they're not issuing any affidavits, so therefore the default couldn't be filed. And now I believe Tracy Burkholder has an attorney that's filed an appearance. And also I can't file any affidavits to do any motions for summary disposition. So I was speaking with Mr. Kirkpatrick yesterday, and we asked if maybe we could kick this out another 30 days and try and, we have been having conversations about a potential resolution with the wife. So that may resolve her issues.
that's fine. Why don't you submit a stipulation with some new dates for pretrial and trial? Leave them blank. We'll fill in new dates for you. Just indicate in the cover letter how much you want me to push it out.
Okay,
Thank you, gentlemen.
Thank you, Your Honor.
thank you, Judge.
And I think that brings us to Clark versus Clark. No, that's not the 1 o'clock, pardon me. All right. I've got someone on a fire tablet. What's your name, sir? Mr. Ellis. You need to unmute. I can't hear you.
Your Honor, I was going to file an appearance in that Burkholder case. My client has never been served, but I've also talked to Mr. Kilpatrick and left a message with the other attorney's office, so I will just have the paperwork in by the time it comes up again.
Fair enough. Did you hear the exchange I just had with them?
Yes, I did, Your Honor.
All right. Just let them know and they can include you on the stipulation.
Okay, thank you.
Thank you. Have a good day.
Thank you, bye.
Just had to be on whatever it's on mute.